Good evening. We begin with the latest in the case of the former city councilor acquitted this week in a DWI case that seems strong. The district attorney says there's no cause for alarm. Even though the former councilor was found not guilty, there's no reason to believe other DWI suspects will get off on the same technicality.
Everything is taken on a case-by-case basis.
DA Carrie Brandenburg says that's important to remember in the case against now former city councilor Michael Cook. The DWI case against him seemed solid. Remember the lapel camera video from APD?
1006, 1007, 1008.
Okay.
It was enough to embarrass Cook and force him to resign his city council position. But it was not enough for the charges against him to stick. A Metro Court judge ruled this week there was not enough probable cause to warrant the DWI arrest, only the traffic violation that led to it. With that, evidence was tossed out from the field sobriety and breathalyzer test, where according to the police report, Cook blew a .10. With Cook found not guilty, what kind of impact could it have on similar DWI cases?
I'm not concerned that this will result in a lot of people charged with DWI getting off, because a lot of our cases are pretty blatant. You have someone running up on a median, speeding, going 5 miles an hour. Some of the behavior is so extreme.
According to the police report, the traffic violation that led to Cook's DWI charge was failure to keep vehicle within a traffic lane. The arresting officer noticed him leaving the asphalt roadway and driving in the concrete gutter.
I do not see this as an alarming case. I don't find the court's ruling as alarming. I find it as an individual circumstance. We have different judges, we have juries hearing these kinds of cases, and we always try to emphasize common sense.
Now, Brandenburg tells us Cook's attorney was not the first to bring up the technicality. In fact, she says defense attorneys bring up the issue at least several times a week. In Cook's case, the defense tactic worked.